So I'm the first speaker. So I do the introduction. I make the introduction. I'm part of Assas Lab because of the sweater. Pièce unique. So we're very glad to host this event that is organized mainly by Kleros and Jan, who did great work in terms of organization for tonight's event. Very happy to host you. So we expect to have a little bit more people tonight, even though we are a bit affected by strikes, which is a typical French institution. Il est allumé. C'est mieux comme ça. So just to let you know about this place. So Assas Lab is the incubator from the University of Panthéon-Assas. It was launched 3 years ago during the first COVID period, just after a strike period, actually. We have about 15 different projects every year, so now we had so far about 45 projects, not only in the legal tech field. We expect to have more legal tech projects, but actually it's quite difficult to attract law students because they do not imagine that they can create their own job, even though most of the time they do, but they don't think that they are entrepreneurs, even though they are. Assas, so the global context, Assas has more than 20,000 students, and 3/4 of these students are law students. But we don't have, as I told you, enough legal tech projects here. So through these kind of events, connections with the real world, we expect to attract more of our students, and not only Assas students, actually, because we think about also having projects with and project holders not only from Assas but from everywhere. Basically, our project is to become the place to work if you have a project in legal tech in France. Well, it's a long-term project. We managed to achieve that project. So, so now you know where you are. And again, I'm very happy and glad to have that even here tonight. Great speakers, great set of speakers, great issues. By the way, I'm not a law teacher. I'm in business management. Sorry for that. But I know about basically what I call the business mechanism. So I know that there is a lot to do in the legal tech field, a lot, in terms of innovation, creating value, destroying value also, but you need to destroy value if you want to create value also. So great opportunities, great issues that we will share tonight with our speakers, and I'm not really good for the conclusions. Hope you'll enjoy your time, and hope to see you again soon for maybe another event with Kleros.
Thank you, Quentin, and thank you for this amazing place that you are giving us. I'm Federico As. I am the president of the cooperative Kleros, which is the company which develops the Kleros protocol. And we are very connected to Assas because, well, we have a Kleros company which is very much involved in research. What we do is super state of the art in terms of game theory, in terms of law. So we have Jan here, who is a student at Assas at the PhD, and his supervisor is Bruno Defin. He's a professor at the Paris Center of Law and Economics, and Jamila, who is there, she's also studying her PhD, doing more legal work. And Jan doesn't work like in theory. And I'm super happy to be here. And just let me tell you a bit about how, since we are not that many, I can tell you a bit of the. We can do more like a point en feu. How do you say in French? I mean, so Kleros started a long time ago already, 2017. I'm Argentinian. I'm not going to speak about football today, so don't worry about that. But Argentinians were very much involved into crypto from a very early stage in the development of the industry because inflation, bad governance, and everything that you might know. And I was seeing, lots of Argentinians already had the opportunity to learn like computer programming and selling services to other countries, having customers in the world, but they couldn't first charge their services. So internet gave them the possibility to study through YouTube, let's say, and then, but when they wanted to make money, they couldn't charge because the banking system was very bad and lots of fees. Crypto gave us an answer for that, so people could now sell their services and then be paid in crypto. But who is going to hire you if you live in Buenos Aires and the customer is in Berlin or New York? So you need some way for solving disputes of nature that are international. Let's say I want to make some design for a website for a customer in another country, and then it's a $500 work. I'm not going to go to arbitration, the Chamber of Commerce in Paris for this amount. So the vision back then was to build a very efficient, very cheap, and very reliable system that could handle this type of disputes. And everything that came later was Kleros. I met Clément because he went to a hackathon. Clément, my co-founder, he's of course French. One day I get an email from a person telling me that she went to be a jury in a hackathon and met some guy who were doing the same thing that I was thinking, and got introduced. That was 2017, and that's when Kleros started. And from that moment, we had lots of work around the way. We did lots of customers. Kleros is now used in. So it started like that with this idea of freelancers and having a system that could be used everywhere in the world. But now we have customers like in insurance, finance, and lots of other verticals, and a very important research department, which was Jan and Jamila. Don't want to bore you a lot more about Kleros, and just for you to know where it comes from. And super happy to be here, super happy to be surrounded by these very smart people. I'm looking forward to this conversation very much. Welcome everyone, and let me give also the word to Jan, who was the organizer of all this event in very short notice. So Jan, please, also so people can know you a bit. Okay, thank you.
So for the first panel, the speaker can come, please. Jana, Christophe.
Tell them a bit about you, Jan.
Oh yeah, sure.
Yeah.
So, well, I'm quite linked to Assas actually, and also Kleros. I'm a PhD candidate with a partnership at Kleros, so a CIFRE, basically. So I'm doing applied mathematics and economics, game theory, social science theory, but also law, and more broadly in law and economics. Trying to formalize the court sourcing mechanism, and plus on Kleros to better understand the behavior of our jurors and make them basically behave honestly. So pretty much it about me, I guess. And I think we can start now. So we have some people through Zoom, fortunately, because of the strike, they were not able to join us. So first thing first, could you basically introduce you quickly, but just would like to be sure, Maxime, Sophie, Jalal, are you hearing us quite well, or is it not that good? Mm-hmm.
So I would say.
So. Okay, I will try to speak a bit loudly, but Yeah, we will see. So maybe start with the person who are physically here.
So, good evening. My name is Jana Lefranc. I'm not a lawyer. Just a disclaimer right at the beginning. I work as an expert in arbitrations. So I quantify losses in quite complex disputes between companies or between companies and governments. And I'm with HKA. And I would like to thank mainly Sophie for inviting me tonight. And I look forward to the discussion.
Good evening to all. My name is Christophe Dugué. I'm a French qualified lawyer, member of the Paris Bar, and what I do is international arbitration. As arbitrator and as counsel, I do have extensive experience in the field of roughly 30 years.
Okay, now, so if the Zoom speaker can introduce themselves, maybe we will start with Sophie, please.
Bonsoir. My name is Sophie Nackert. I am a Canadian who lives in London for her sins, and I apologize that I cannot be with you this evening because the strikes have had quite an effect on the cancellation of my trains. But it's great to see you even remotely. I am an arbitrator, and I've been doing this full time for the past 15 years, and before that I was a counsel and advocate in international arbitration at a multinational law firm.
Thank you. Maybe Jalal?
Yes, of course. Can you hear me?
Yeah.
Yeah, very good.
Okay, great. Thank you, first of all, for having me, inviting me. Thanks, of course, to Sophie, Federico, Quentin. My apologies as well for not being able to come, although as opposed to Sophie, I do not live in London, so I didn't have to take the train, but for personal exigent reasons, I am stuck in the place where I am here, but hopefully we can make this up. I salute also Jana and Christophe, whom I know, and I'm delighted to share this panel with Maxime as well and Sophie. As far as I'm concerned, I am a partner with a law firm called Bird & Bird here in Paris, and I do international arbitration both as a counsel and as an arbitrator. My three major geographical areas where I practice are Europe, obviously, Africa, and the Middle East. And I do also some disputes, including tech disputes, but also investment, sports, construction disputes. Thank you.
And finally, Maxime.
Thank you very much, Jalal. Bonsoir, everyone. My name is Maxime Chevalier, so I'm also a French qualified lawyer. I initially started my career as an academic where I was teaching law in India at Original Global University, where I had time to research on blockchain law and arbitration. And I now work with the Mexico office of the international law firm Curtis Mallet-Prevost, Colt and Mosle, where I work mainly with the international arbitration department. And of course, whatever I will say reflect my own view and not the view of my firm today.
All right, so I suggest. Oh, sound issue, sorry. All right. So I suggest to start this panel about arbitration, including decentralized justice, with this very known question and kind of recurrent. So do you think that decentralized justice, like Kleros, could be qualified as arbitration? So who would like to take the first shot? Maybe, please, Christophe.
The short answer is no. I can elaborate on the reasons. Okay. Very briefly, Okay, so you give me 3 minutes? Okay.
No more.
Okay. As I understand it, and I've been provided with some information by Kleros itself, what are the advantages of online justice, or so-called justice? It's accessible, it's quick, cheap, can be accessed not depending on time zones, working hours, jurisdiction, so it's quite interesting for that purpose. It's suitable for anonymous parties, and it does not require that a specific law be applied. So it's compatible with what was in the script for our conference tonight, the global metaverse jurisdiction concept, whatever that means. It does provide decision by jurors that can be, I understand, selected or promoted by Kleros based on their knowledge of a certain industry. It should not show bias, as I understand it, thanks to the game theory. And one important feature is that it produces self-enforcing decisions, I think, most of the time. That's for the pros. Now the cons. It's, in my view, viable only for very small claims that can be answered by yes or no. Maybe I'm wrong, but that's what I understood from the description of this protocol. The people who decide are jurors, not arbitrators, and they intervene on the basis of anonymity. Their name can be known, their identity can be known, but when they vote, their identity doesn't show. Hence, they have no disclosure to make to the parties regarding their independence and impartiality, as arbitrators would do. They cannot be challenged or replaced by the parties, nor removed. And they do not conduct actual proceedings, as we know in arbitration, with the lengthy exchange of briefs, sometimes 2 rounds, hearings, witnesses, experts, and so on. And what does Kleros' decision look like? So I've been provided with a printout in 5 or 6 pages, where you identify first the court in the Kleros language, and I've been provided with the Humanity Court sample. Then you have a page that relates to the timeline of the case from the evidence period until the so-called enforcement of the decision. Then you can access the proof of humanity in my sample registration request, where you find what is at stake. And then, in fact, you have a summary of the dispute. My video accompanied by a photo showing my face. I didn't want to mislead anyone by looking at my photo, but my chin is covered in the video, and what I understand to be the other party says that face of submitter on video does not follow requirement, and the fact that the chin is covered makes that it might distract humans or algorithm from being able to detect identical faces. And then the last page and the decision is just yes, no, and the answer was no. So I suspect that the claimant failed. I would hardly describe that as an arbitration award. The form is very succinct. The content is not very detailed. There's no reasoning, there's no law applicable, no principle discussed. It's a decision in the form of a yes or no answer to a simple question. So in my view, it does not correspond to what can be described as an arbitration proceeding or arbitral award, either under French law or UNCITRAL model law, or in the New York Convention. By the way, I won't take too much of your time, but those do not describe what is arbitration, neither what is an arbitral award. But if you, there's no specific definition, but if you look at the essence of arbitration, it does result from three elements. The first of those elements is the existence of an arbitral tribunal that decides a dispute by applying the rules of law, which is a law chosen by the parties, and their decision is called an arbitral award. Hence, the answer is no.
So, thank you. Just bringing some information, technical information about Kleros. Actually, right now, Kleros is working on a majority rules mechanism, but we are launching the version 2 of Kleros, where we will be able to have a ranking vote method, so it will be way more than yes and no, but right now, of course, it's working with yes or no, but it's just a matter of time to shift. Also about the independence, well, basically what we're trying to do with game theory and our selection function is to put a lot of randomness in order to make the likelihood very low for basically a person to reach a case that they have an interest on. Of course, the Kleros protocol is aware of conflict of interest, but we are looking for the atomicity of the blockchain ecosystem industry. So we fairly think that at some scale of this ecosystem, it will be not probable to get selected as a juror on an offer that we are a party on. And finally, about challenge, we can actually challenge the decision, which is a very important mechanism on Kleros. Basically, parties and jurors can challenge it, and they even have interest to challenge any decision that they consider wrong or even biased, or if there are some bribe or whatever. So just those information. I will let maybe other speaker to talk. Maybe Maxime, I'm pretty sure you want to add some stuff.
Maybe Jana, you want to say something, or I should start, or yeah? So maybe I will agree and disagree with what has been said, because of course Maître Christophe Dugué presented the Kleros very well, and he's right saying that it's not what we do right now in arbitration. We don't exchange a brief, we don't discuss bifurcation, we don't have this restaurant schedule and whatsoever, but this only represents 1% of what arbitration has been before. Arbitration is more than 2,000 years old. If we look at what was done in terms of arbitration in Marco Polo's desert caravans, they would just fight over goods, but they wouldn't exchange brief. Also, if we compare the justice from the state, I guess you all know the story of the Roi Salomon, who had two women fighting over a baby. He suggested to cut the baby, and one of the women said, no, I want this baby to live, and she got the baby. This was justice as well. And yet we didn't have exchange of brief, we didn't have a written decision, but yet this was justice. So I think that we should change the approach we have toward blockchain arbitration and stop trying to fit it with what we do right now, but just have in mind that arbitration is a justice provided by a third party, which is not the state, which renders a binding decision. Well, on Kleros, that's what we have. We don't apply a rule of law, we usually judge as amiable compositeur, or we sometimes apply what we will call the lex cryptographia, which are standards governing on the blockchain itself. But I do believe that, yes, it doesn't fit with exactly what we do right now, but this is arbitration, and we will see how it evolves later. But I do believe that Kleros, if we see arbitration as a whole in terms of history, Kleros is arbitration, because we have a dispute mechanism with a binding decision that is enforced on the blockchain.
Maybe Jalal, Sophie, do you want to add some words?
Yes, Sophie, please.
Thank you. Right. I think this is the wrong question to ask. It doesn't matter whether Kleros is or is not arbitration. Arbitration is a defined term. It has clear references in the New York Convention, of course. it has become a private means of dispute resolution that is ubiquitous in certain types of disputes. It is, to my mind, irrelevant almost in the online system, the ecosystem in which decentralized justice seeks to operate, whether it is called arbitration or anything else. Because what really matters is, as with any dispute resolution system that is not imposed, that is chosen, what really matters is whether it attracts the trust of its users and whether it delivers an outcome that the users consider acceptable and fair enough for their purposes. That is what really matters. And also, decentralized justice is self-enforcing at the moment. Where we run into problems of nomenclature and definition is if a decision on-chain is taken off-chain for some reason or another. And here we have the difficulty of characterizing what it is that this decision represents. But for the time being, there's absolutely, what we are seeing developing with phenomena such as Kleros is a landscape, a much more varied landscape of dispute resolution offerings for users, depending on the type of dispute that they have. And you can have purely automated dispute resolution systems on the one hand, and on the other hand, the very complex, multi-party, multi-layered disputes that are what international arbitration can be. And then in the middle, you have this bubble of more commercial disputes, high volume, low value, that are not being adequately served by traditional arbitration, and for which decentralized justice can represent something extremely attractive. So the short answer to the question is it doesn't really matter insofar as arbitration, as we practice it, remains suited to certain types of dispute, and then decentralized justice becomes suited to something else. Thank you.
Jalal, maybe a word?
Yeah, I think it was Jalal that wanted to add something.
Sure. Well, it's going to be quite a challenge to come after three very relevant speakers and contributions. I think Christophe was, as always, clear and straight. So he tried to answer the question. Maxime, if I got him correctly, reminded us about what is justice, to take a very long perspective, and this notion can adapt, including to what we see arising today. And then Sophie reminded us about what actually mattered, which is that arbitration is also, but mainly focused on, I wouldn't say the users, but making sure that the users are satisfied with this method of resolving their disputes. And this is perhaps what the decentralized word is about, whether it meets the expectations of the users. I would add my here, based on all of that, which is obviously very relevant and on point, perhaps three little bits. I remember a very nice article prepared, drafted by Jean-Baptiste Racine, who was actually asking three questions. So I wouldn't say that, of course, the questions put to us is not relevant, but I think it is superseded by those three questions, which are whether it's technically feasible, whether it's legally possible, and three, whether it is desirable. To be honest, I've been thinking about those questions before coming, and the answer is really not easy. What I can say, and this applies to arbitration as for any sort of artificial intelligence tool applied to arbitration and justice in general, is that you see a fundamental tension, and I don't know how it's going to be resolved in general and especially in arbitration. One, it seems like we want something more cost-effective that takes less time, and to speak to the point made by Sophie, that meets the expectations of the users, which is to be less expensive and to the point. And ideally, what we want is something that does not make any error. That, of course, is very much like a robot. At the same time, it seems like what we also want is a human justice rendered by people precisely with their flaws, actually a bit of bias, because we don't want someone completely clinical, completely unbiased. So those defaults, this is something that is probably also expected. What we want at the same time as a perfect justice is an imperfect justice. And you see the tension, which is basically very human, which is, it reminds me of this movie you've all heard of, Everything, Everywhere, All at Once. We want everything and its opposite. And I think this is what we're discussing. We want something perfect and we want something imperfect. Can we find a compromise between the two? I don't know, but all I'm saying is that it is not today that we can solve this issue. And the three layers I just put, technically possible, legally possible, and desirable, is really something we probably ought to address today. Thank you.
Thank you, Jalal. Actually, it's a very good introduction for one of my questions. So, first, I would like to say we have a growing digital economy, and so globalized, and we have new tools like predictive artificial intelligence for decision. We have decentralized justice with their characteristic, enforceability with smart contract, low cost, and the speed of decision. According to this, do you think those tools are in competition with arbitration, or do they complete arbitration? And I would like to start maybe by with Jana, if you want to.
Maybe just on the topic that that has just been discussed. Well, to me, what Sophie said makes a lot of sense. So, is it? I don't want to fit Kleros into the question whether it is an arbitration or it's not an arbitration. It's a form of how people can resolve a dispute. What I like about it is the combination of what Jalal touched upon, the combination of having technology but the human aspect to having jurors behind it. At the same time, what I don't like about it is in the arbitration process, you choose your arbitrators, you choose them for a reason. You want somebody who understands the topic that is being decided, so who has a profound knowledge. And I guess maybe in the type of disputes that currently Kleros deals with, maybe that's not required, but that's what I'm familiar with, and that's what I see, what I would be seeking when I'm looking for somebody to resolve my dispute. I want somebody who understands the topic, and I don't currently see in Kleros how that can be assured.
I don't think that they compete. They supplement each other, and I tend to agree with everything that's been said earlier. they do not answer the same. They do not serve the same purpose. It's the idea is to provide justice to people. The important feature in Kleros is that, as was said, it remains human. Hence, justice is a matter of trust. You need to produce something which is not only enforceable, but acceptable by the parties. And that's why we have those lengthy hearings in arbitration, because the parties want to be heard, they want to have the time to present their case. Obviously, for other type of disputes, and I think Kleros serves perfectly, plays its role perfectly here. For very small amounts, obviously, when you have a dispute with someone abroad, there's no point in resorting to courts, not to mention arbitration. So we're not playing in the same category. So there's absolutely an advantage here. What you want also is something which is enforceable, and maybe one possible evolution of Kleros will be to make it a possibility to have higher amounts at stake, enforceable through the same idea of this protocol with funds already deposited and then attributed to one party or to the other, which is very interesting, a very interesting feature of what Kleros offers. But again, Kleros might develop in different way. I think it's a good idea not to characterize it as arbitration, because it might raise more issues that it's good in terms of PR for marketing purposes, but as a practical matter, it raised too many questions, and as I said, the answer is no. So it doesn't help much. But a number of points that are dealt with by arbitrators in council in arbitration proceedings might be introduced into Kleros to extend the scope of its use, provided that it's also a way to build confidence with the potential users.
About the trust, basically, the promise of Kleros is for any party to get access to jurors that will behave honestly and in a fair way, so they will not have any conflict of interest, and this with a fast process, right, and specifically well designed for digital environment. So that also how Kleros aim to be designed with the notion of trust. Obviously, it's quite challenging because we are using game theory, social choice theory, and some type, so basically secure about maths. And yeah, I completely understand the conflict, at some point philosophy conflict, but this is basically the promise of Kleros, and all the design is made in this sense, basically. Maybe Jalal, Maxime, Sophie, would you like to add something on this question?
I'm not sure that I understood what the question is. Sorry, the sound is not
no problem.
Great at my
So competition between arbitration.
Oh, competition.
Yeah.
Yes. So competition. So complement with arbitration. The complementarity of predictive AI or decentralized justice. There's no question that there is great scope for complementarity, in the same way that arbitration has partnered up with more facilitative means of dispute resolution, such as mediation or conciliation, for example. So there's that I think there is great scope for that. The competition with arbitration that I see is to arbitration's disadvantage. The arbitration has bloated itself out of the market. It has become extremely expensive, and it's very time reliant and time heavy. And the difficulty with that is when you look at the arbitration process that we know, and you look at the digital economy is instantaneous. The values of those who use the economy is that they value the immediacy of transaction and the immediacy of result. And so in looking for a system to resolve their dispute, they will want something that mirrors those values. And the problem of arbitration at the moment is that it's completely irrelevant and unable to meet that value unless it looks I think this is a fantastic opportunity for the actors of traditional arbitration to look at the process and try to devise a means of preserving its integrity, preserving its due process in a much more streamlined fashion. It is time, I think, because what will happen is that those users of the digital economy, which is all of us really, eventually, if not already, will come to expect a more immediate result. And they will not be willing to wait a year, let alone 3 months, let alone a year, for a decision in this, unless we're talking about extremely high stakes dispute that need precedent. And so I think the competition with arbitration is precisely at that level, where arbitration, if it's not careful, and if it keeps clinging to the current model, will put itself in a position that will be irrelevant for these types of disputes. And I look at what's being done, for example, at the DIFC with their digital assets court, and where they are looking precisely at these challenges, where they want to attract the disputes that arise out of that space. And for that reason, they have to go back to the drawing board and look at a process, a procedure that makes sense and that mirrors the values of those users that they want to attract. And I think arbitration should urgently do exactly the same thing.
Maybe Maxime or Jalal?
Jalal, if you want to go?
Certainly, thanks, Maxime. Again, quite challenging to come after Sophie because I concur with what she's saying, but beyond this, because she's really, I think, raising a very valid point, which is probably that the time has come for the arbitration users, practitioners, stakeholders, perhaps not to question themselves, but to no longer satisfy themselves with the idea that there have always been this very nice international justice by default, because there is no other international justice. And I think it is, I am confident that this challenge can be overcome, because as Maxime has reminded us, arbitration has existed for thousands of years and even before state justice, because state is a very modern notion. And I do trust arbitration as a concept, as a notion, and even as a mechanism, as a tool for its capacity to renew itself and to basically embrace those new challenges. That's not just a wishful thinking, but just a very deep conviction, and which explains why I love arbitration. Now, having said this, to answer your question about competition, competition does require that you don't compare apples and oranges. And I'm not sure we're not doing just that here. I'm not sure that what the digital users Sophie was referring to, but in general, those who are looking for a way, let's say, to resolve their dispute, are actually looking at the same thing when they go to arbitration. And it may be that eventually arbitration will be this very sophisticated justice. As, for example, criminal justice remains this very specific type of justice where you do still need due process and to guarantee some fundamental rights, etc. Whereas the vast majority of other commercial disputes will be resolved in another way. Will it be still justice? Perhaps. But will it be the formal justice that we've been used to for, I would say, decades, if not more than that? I'm not sure. And this is why I'm not saying that there is a competition here. It is probably going to be two levels of justice living together.
Maxime, please, if you want.
Thank you, Jana, and I actually totally agree with you, but it's a tough question because I think that traditional arbitration and blockchain arbitration are at the same time in a competition, but yet complementary. And I will give you a very interesting example. For example, on the blockchain now, we can create DOs, which are decentralized organization. It's basically a company which relies on a smart contract. So instead of having like status of incorporation in a given legal order, we have this company, this organization, incorporated on the blockchain. Well, if you are a shareholder, you own what we call a utility token. So it's like a crypto asset, a token which will allow you to vote, take decisions in this decentralized organization to receive profits, maybe, if this organization makes investment. Well, let's say we have a dispute about the decision that should be taken in this decentralized autonomous organization, or we have a dispute with the assets that this organization owns. But let's say at the same time, your organization, the blockchain, owns assets in a given legal order in France, in the real world. It owns real estate assets. Well, we find ourselves in a situation where we will first resolve the disputes on the blockchain about the decision that should be taken or the disputed assets. So we will have a blockchain arbitral award that will be enforced within the blockchain ecosystem. But maybe this will impact real assets owned by this organization in the real world. So at the same time, we need to interact blockchain arbitration with traditional legal orders, and that's where we will have to discuss how was the res judicata effect, how we can actually enforce or at least recognize a decision from the blockchain legal order. So you see, for one situation, we might have, for the same common project amongst people, some of the disputes that will be resolved on-chain, for example, to take a decision about the decentralized organization, but at the same time, it will impact the world off-chain, and maybe for the assets off-chain, we will need to have a parallel arbitration happening off-chain. Well, then it becomes very interesting because we can see that for the same disputes, the two processes are very useful. They answer different questions, but they are yet very complementary. And I totally support the idea that blockchain arbitration actually is detached from any national legal order. We don't have a seat of arbitration. No courts can annul the arbitral award. It's independent because we have the three powers of a legal order. We can formulate rules, we can adjudicate disputes, and we can enforce rules within the blockchain ecosystem. So yes, the blockchain arbitration system is independent from the current legal framework, to answer the question too, but at the same time, it will still need to interact with other legal orders. So we will have to find a way to adapt the interaction between the in-chain world and the off-chain world.
If I may here just add 1 second with the permission of our moderator.
Sure, please.
I think we will have to adapt, and I think, Maxime, you're touching upon a very important point. We're not yet there. The reason being that when it comes to apply a blockchain based decision to the on the ground old world, as you probably know, and I'm sure you're aware of, the few decisions that have been rendered today, whereby you had very similar type of rendering a decision as Kleros. All those decisions, at least in the Netherlands and in China that I'm aware of, based on blockchain, have annulled those decisions for various reasons, due process, or because there is a lack of motivation. You don't know how the decision was actually processed and reached, but for all those reasons, every time you try to implement this, what appears to be a workable solution in the blockchain environment and apply it to our old and good habits world, it doesn't work. So that connection is still to be made and created somehow.
Thank you. Just to add something, that has to do with the instantaneous character of the blockchain decisions mentioned by Sophie. It happens sometimes that when applying what's been agreed by the parties that produce an automatic result leads to a dispute, because you have first, and that's the notion of on-chain and off-chain that has been discussed by Maxime. In an arbitration in which I made an award that had to do with a blockchain cryptocurrency dispute, the outcome of the automatic resolution of the situation was the automatic liquidation of a portfolio, but this raises an issue because it's not accepted by at least one of the parties. So the essence of arbitration does today is to provide a solution to parties that do not accept the outcome of an automatic process leading to a solution which as such is self-enforced but nevertheless not accepted, hence a dispute, and there's still a place today for arbitration. But maybe the existing systems will both evolve to make arbitration more user-friendly for this kind of dispute, and at the same time, maybe as Kleros is doing, provide more sophisticated solutions than they are today, and maybe we will see a competitor emerge and less work for arbitrators.
So,
if I can add on something that Christophe said that
Sure,
was
please.
very, very interesting. So Christophe explained that he had a dispute as an arbitrator based on what had already been disputed over the blockchain. I mean, it was automatically enforced and the parties didn't agree. Well, there is a very interesting case that happened with Kleros, actually. There was a dispute about a real estate and the parties adjudicated their dispute on the blockchain. And then this decision was actually enforced through a real traditional arbitral award, meaning that we used the blockchain arbitration first, then it was incorporated within traditional arbitration because it was then written in an arbitral award and then enforced. In that way, what happened on the blockchain was, let's say, it became legal because it was then incorporated by a human, a real arbitrator in a written award. And in that way, we can see the complementarity as well between first a blockchain arbitral process and maybe having transcripted this process inside an arbitral award made as per the New York Convention and then enforced. And this happened, for example, in Mexico, and Mexican courts have recognized as a valid award this blockchain award, then incorporated in, let's say, a sentence accord party with traditional arbitration. So that's very interesting to see how we can have these interactions between blockchain disputes then incorporated in traditional arbitration award.
I just wonder how that is possible, like incorporating an award if you do not have a reasoning behind it. How could they have incorporated it into their decision? I mean, they have to know the reasons for reaching the decision, right?
Well, I think we need a little bit more context. I mean, the Mexican decision, which is the one that I'm aware of, had to do with the recognition, under Mexican law apparently, the will of the parties is paramount. And if the parties decide between themselves, we will flip a coin to decide this dispute, that's valid. And so therefore, where the parties agree in an agreement, in a contract, we will have this dispute decided via Kleros or via a decentralized system. Mexican law recognizes that as valid. And so it is in that context that the judge then said, well, the parties have spoken, they have chosen that mechanism, Mexican law allows it, it's fine as far as I'm concerned. There was of course, no reopening of the process, not even to my knowledge, it's a very short judgment, any probing of how this was rendered, because of the context of Mexican law. Now, that is not necessarily the case everywhere, but it is the case in those jurisdictions that have that provision. And you know, it's just as valid as flipping coins for that matter, as long as the parties agree that they are going to be bound by that.
So maybe to just add on the competition point that was the question previously. So this to me goes back to actually the first question. So where there is a demand, so if there is a demand from the users to have a system such as Kleros, and they are happy with the answer yes and no, well then in that case, you know, that works. It meets the demand, and therefore there will continue to be a supply, if I put it this way. So it's the parties driving, and we will see whether the demand will be there.
Okay, so maybe to finish this panel, I have one thing to say that I find quite interesting. So I was at a conference at Oxford University with the Center for Socio-Legal Studies, and about the future of dispute resolver, they have addressed some requirements, strong requirements. So I'm quoting first: dispute resolver should bring more advice and assistance to both people and business. Do you hear me well on Zoom? I think it's quite important for you to hear those quoting. Do you hear me well? Maxime, Sophie?
Sorry, I didn't hear the question.
Oh, no. So, no problem. Yeah, sure. So, tell me if you're not hearing me, please. So, I'm quoting the Center for Socio-Legal Studies from Oxford University. So, basically, they say dispute resolver should have more advice and assistance to both people and business. Dispute resolution system should operate as a larger regulation system that supports good behavior, risk reduction, and prevention. So regarding those requirements, do you think arbitration and its legislation can perform it, and obviously at the light of this decentralized justice, basically? Who?
Yeah, I mean, I've studied Kleros quite a lot, and Kleros doesn't only adjudicate dispute, but it has also other mechanisms like curated lists or proof of humanity. If we take curated lists, for example, we have a list of different things, and then people will put these elements in the list, and the jurors will decide whether it has to be in the list or not. So we have a curated list because everyone votes. We can challenge when something is added to the list, and we decide whether it has to be there or not. I think that's very interesting. What if, for example, sometimes we discuss that big companies, they took wrong decisions that actually do not respect compliance or do not respect environmental law or whatever regulatory framework? What if some of the decisions actually are first validated through a pool of jurors that will together decide, let's say 100 people or 101 to have a majority, and together they will decide whether this decision to be first taken inside a company is in compliance with the regulatory framework. That's just an example. But in that way, the Kleros system or blockchain or decentralized justice can help actually, for example, in the decision-taking of big companies. And in that way, we will have a sort of internal validation of the decision to be taken by a company, so we make sure that as a preventive system, it actually respects the regulatory framework. So yes, I think that blockchain arbitration can be really helpful to actually implement or to have preventive action as per the regulatory framework.
Sophie, Jalal, do you want to bring some words?
I commend the Center at Oxford for a truly utopian viewpoint. If I can speak from the trenches for 2 seconds,
please.
where things are not as rosy as they would like it to be, I can tell you that when you have disputes, no matter how high the stakes, but where you have humans behind companies or personally, who are not agreeing with each other, The last thing that they wish to do is cooperate and organize good behavior between themselves. And it is often not in their interest to be so belligerent, but that's the way that they are. And when they come to arbitration, as we know it, which is an adjudicatory mechanism, it's not a facilitative mechanism in this part of the world anyway, it can be elsewhere. They want to have a cut and dry decision, and they want to understand the reasons behind it. What the center proposes is a completely different approach to litigation and litigiousness. And I actually wish for that to take a hold, but this is very much in the hands of the parties and the users. Again, any private means of dispute resolution that is chosen is very much a service to the users and to what the users want. And at the moment, I can tell you from where I sit that the users, when they have decided to go to arbitration, and they're often very sophisticated and they've exhausted a lot of negotiation and trying to facilitate an outcome, and by the time they come to an arbitral tribunal, what they want is a decision, and they are going to stop at nothing to put their case forward in as, I wouldn't say aggressive, but as forceful a way as they can. So I would say to the center, keep at it. It might take hold at one point, but for the time being, it's just not what I'm seeing in the real world.
Jalal, maybe, or Christophe?
I can speak, but I'll let Christophe speak first.
Thank you, Jalal. I fully agree. I mean, it's for the parties to be reasonable. You cannot force them. You cannot educate them. So I would think that the effect of arbitration is indirect in this regard. It facilitates things once you have already discussed in front of the arbitrators, not always in a reasonable manner, because you know that someone you trust will render a clear-cut decision. But I don't see, it's not the main purpose of arbitration or litigation to provide this kind of environment. I mean, people want to fight.
Well, in what context?
In context of digital, in dispute in general, I guess, and also in blockchain ecosystem, because it's working a lot with this, DAOs, decentralized autonomous organizations. So there is this spirit of we may have an interest to cooperate. So in a game theory perspective, obviously. So that's why also those ideas are quite interesting and relevant for decentralized.
Well, I think
in my opinion,
I think we forget that blockchain it's based on a script. It's not a human. So again, I'm not a lawyer. I'm an economist, an accountant. So what I see, I completely agree with Sophie, but I kind of disagree with Christophe here, because I think people don't want to be in a dispute. They are, what I actually see is it's the last resort. So what I see is people try to avoid disputes if they can before reaching to arbitration. It's not something they choose willingly. They end up in the process, and then they are looking for a decision. And in my experience with working with general counsels, and there might be a space for speeding up the process, which is what Sophie touched upon. In my experience, the general counsels, when they reach the point and they launch arbitration, they want it fast, resolved. And maybe if it's not a perfect decision for them, what matters, it's resolved quickly, and the outcome can be, I don't want to say predicted, but reason, but whatever almost the outcome is, it needs to be resolved quickly, because they need to get on with the business. They need to continue cooperating with the party with whom they have the dispute. They usually are, subcontractors. They continue doing business together, so they just want this to be sort of resolved over and continue working together again. So again, in that sense, I see Kleros as a possible efficient resolution. I don't want to call it arbitration, but it's a resolution that can serve the purpose.
And Jalal, do you want to add some words?
Okay, I'll try to be quick. I promise. I think the Oxford proposal is, I wouldn't say utopian, but focuses on probably what we call today mediation, i.e. People really willing to find a solution in a cooperative manner. Does it correspond to the reality of the disputes in general? Of course. Many people would try to not to basically go through a process that costs, so if they can avoid it, they will try. But the reality, and I've been working on mediation for years and years, it's not working, or rather, it is working when people want to cooperate. You have an 80% success. But the reality is that when parties fight, and they want to fight, they don't want to mediate, they don't want to be cooperative. That's the reality. And this is perhaps why mediation hasn't been working more than what we all wished. Now, can we improve things? Perhaps. I think, as I said earlier, arbitration can adapt to something more effective. I would like to remind everyone that the New York Convention does not say that the human being has to render the decision. So theoretically, you could have an artificial intelligence, as per the New York Convention, rendering an award. It's different in national legislations. But again, in theory, that would be possible. Can you live without the due process, i.e. by flipping a coin, exactly like you, in the Mexican decision that was referred to? Well, yes or no, even if it's no, even if it was agreed upon. And I refer to that Dutch decision I mentioned, the Amsterdam decision. Basically, the judge said that it was not possible to recognize the award simply because one of the parties was not properly notified. So is proper prior notice or proper notification an element of due process that you can live without? I don't know, perhaps not. I can tell you that a very interesting judge said in an NFT dispute that the way you can basically give notice to an owner of an NFT, i.e. by leaving like a ticket on the NFT itself, could be proper notice. So you see, you can have new case law evolving in a way that even due process can be reinvented in a way more effective.
Thank you, and it will be the last words for this first panel. So maybe there is a few questions.
No, first, you have time for questions, I think.
Yeah, like 5 minutes, like
5
a
minutes.
few questions if there is.
One question.
Okay, yeah, sure. I know we are almost right on time, but yeah. Please.
Very quick one. As we were talking a lot about trust and the confidence of users and what the users are looking for, I'm just curious whether Kleros has done any kind of survey or that has looked into user satisfaction in any way, whether there's users are actually reporting that they're happy with the way that their disputes are decided or not.
Sure, I got the question.
So the question is about the survey about satisfaction of Kleros users. So basically, we did it, but for proof of humanity, which is another protocol of Kleros. But actually, we did not do specifically this. We did a survey to better understand the profile of jurors right now. But obviously, it's a very interesting things to explore. So in the near future, yeah, we will for sure. But we waiting for more. I guess user we are growing quite fast, but I think it's not enough to really have a strong opinion on the satisfaction or not of users.
I have just a question. So, how Kleros avoid risk of coalition?
So we do it with the mechanism of appeal first, and also our staking mechanism. So basically, when you are jurors, you are putting at stake some of your money, right? And so your interest is first to not lose your money, and the second interest is to win money by reaching the chaining point. So basically, jurors that think that there is some collusion, or even parties that think there are some collusion on this dispute, have interest to challenge the decision and then to be able to actually get the stake of the jurors who basically collude. So it is on my interest to challenge a decision where there is collusion, and we think of opening basically the challenge mechanism for collusion for any person who could basically first put at stake some stuff, and second, to prove that there is a collusion.